Our next speaker is Katherine Henry. She's a senior attorney of Katherine Henry PC and the founder of the Restore Freedom Initiative, which is a proposal to amend our state constitution to rein in government power, prevent future abuses of power by the governor, the legislature, and the courts, and restore Michigan to a government of the people. Abraham Lincoln once said that America will never be conquered from without, but if it falls, it will fall from within. What Katherine's going to talk to you about is very critical, because if we fall, it won't be from Russia or China. It'll be from the folks with these bullet points on the left down here that are seeking to overthrow our government and destroy our culture. And we need to have rule of law, and we need to take back our country. Without further ado, Katherine Henry.
Good evening, everyone. I don't know if they warned you, but I was coming straight from volleyball, so... No one's ever accused me of being athletic, so... But at least I had another pair of shoes to change into, so that was important. I had been asked to, I'll get my notes here just to make sure. For someone who has never been very popular, I've been asked to speak at a lot of events recently, so I got to get my bearings about me. I guess actually something that would help me, just to get context of who's in the crowd and what you guys know, if you have seen me speak before or you know who I am, can you raise your hand? Oh, wow, okay. So quite a few of you. That's very humbling because I'm just a nobody with a law degree. So I was specifically asked to talk to you about the recent Supreme Court decision, the situation with the Christian high school in Hudsonville, and the Restore Freedom Initiative petition, which of course would be my favorite thing to talk about since I wrote it. Usually I get a chuckle out of that one, but that's better. So I did want to kind of touch base, hopefully strike a good balance and not being too close, too far from this microphone. Did want to touch base on a few, there's so much happening right now, right? It's insane. The second I feel like we're starting to make headway on something, then the government throws 12 more things at us, and there's not enough attorneys standing up to do the right thing. So I feel like I'm drowning. Because I can't imagine not fighting every single day to fix this, and I want to know why there's so many other attorneys that are licensed in the state of Michigan, but they're nowhere to be found. So, needless to say, I'm not out making friends these days. Well, greed, there's a few other things, and there's, we could go on, but... it might sound a little bit off topic from the three things I was asked to talk about, but they all blend. So, and I'm all for answering questions as well. Where we find ourselves is we're in a situation, we're in a state of Michigan, but also the state of COVID, where we have a legislature, Republican-led legislature, that passes bills that require things like, people have to wear masks in public. How many of you guys know that they did that? April 30th, Senate Bill 858. A few of them tried to come out of the session of legislature telling us how wonderful it was, and I was like, not so fast. Let's read that first. They actually, on April 30th, voted. Both the House and Senate passed it, and we're lucky, we're thankful that the governor vetoed Senate Bill 858. It was unconstitutional for a variety of reasons, but she had at the time maybe 59 executive orders, and in that bill they voted to codify 29 of them in their entirety. Just adopt 29 of her executive orders. So half of the ones that she had written at that point. Not a single one of them has been good in and of itself. So not a single one of them should ever be entirely adopted by the legislature into law. But they did that. We're also in a state that we have a legislature that recently voted to prohibit people from going to work if you have a fever or a muscle ache or a sore throat without a medical determination that it's for another reason other than COVID. So basically, you have to go have a COVID test in order to determine that you're allowed to be at work. That was done last week. Our governor signed that into law last week. Yeah, Thursday. That would be House Bill 6032. I'm going to say some names. Oh, you know what? I have the bill with me. That's even better because I don't have to go off of memory because I got a lot rolling around up in there. Mostly about missing volleyball shots. But. So, I'm just going to read off the ones that I know of. Representative Tom Albert, Representative Tommy Brand, Representative Allor, Stephen Johnson. Anybody recognize these names so far? Some of them I've considered friends for years since I ran for state rep in 2015, 2016. Representative Julie Alexander, Luke Meerman, Julie Calley, Jim Lauer, Beau LaFave, Markkanen from the UP, Matt Maddock, and a variety of others. Those are the ones that off the top of my head I know that I know. These are just some of them that introduced this bill. The bill that you can't go to work if you have a fever, muscle ache, sore throat. You know the things that happen to the people in Michigan that have winter? Yeah. It gets worse. I mean, I could go through the details of that. So that would be, it's now known as Public Act 238 of 2020. And what's worse than that is all those conservatives introduced this bill. And how many do you think, just somebody give me a number, how many do you think in the House voted for this? Out of 110, how many do you think voted for this? 101. 0 voted against it, and 8 didn't vote. And we must have one that's not, I guess I didn't realize we had a vacancy. We must have one there's a vacancy. In the Senate, what would you guess? Out of 38, how many do you think voted for it? 37, 0 voted no, and 1 was not voting for whatever reason. So basically unanimous. Unanimous and introduced by Republicans to require people, to prohibit people from going to work if you have, I don't know, you played volleyball, you were terrible at it, you go to work the next day, you're like, gosh, that probably was from that game, but you know, I'm just kind of achy or whatever. I'm going to pick on my husband because he's 8 years older than me. You know, he could say, gosh, I'm an old man. This is, you know, he also plays hockey, so he could be like, oh man, it could be that hockey game. I don't know. Oh, if you're overheard saying that, you got to go home and you can't come back for at least 2 weeks. And then the other side is, now, so his employer wouldn't be able to fire him. Okay, so that's good, I guess. But then what about all the small mom and pop shops that people have the normal sniffles and things like that? Because there's other symptoms that are listed in this. And then they can't go to work, and then they're not allowed to fire these employees or like replace them, or what are they supposed to do? What is wrong with these legislators? Reason why I'm not making friends these days, because apparently I'm the only one paying attention to stuff that that knows these guys, that's going to call them out on their crap, regardless of what letter comes behind their name. And I'm assuming the rest of you in this room, that's why you're here, but I could be wrong. Another thing that an employer shall not discharge, discipline, or otherwise retaliate against an employee who does a variety of things, but one of them is even reports health violations related to COVID-19. Now, what would a health violation related to COVID-19 be? Pretty sure it means that you're not following one of these illegal and unconstitutional emergency or executive or whatever order they come up with next. So our legislature is saying, you can't fire somebody for turning you in to the mask Nazis. The Republican-led legislature did that, among other things. This bill is not even very long. I mean, that's it. And there's more damage than I can already, I'd spend the rest of the night telling you how awful it is. Hope you guys are calling people when you get home, I'll tell you that. Because this is insane. That's not the only, okay. No, I do want to tell you one more thing, because this is disgusting. How many of you remember House Bill, I want to say it was 5672. I kind of blew open the whole thing on that when they were trying to say, well, this is the House bill that it's good for us because they're fighting for our freedom, because then it'll stop us from having employers require us to be microchipped. Anybody remember that bill? Okay. Well, the thing is, the way the bill read is that, and I don't know where it stands now, it passed the House, 107 voted in favor of it, 2 voted against it. Bo LaFave, I believe, and Steve Johnson, but we'll talk about why in a second. So the bill, there were 2 concerns that I had with it. One is that if your employer violated this law and they went ahead and tried to require you to be microchipped as a condition of employment, then all you were allowed to do was get actual damages, meaning you had to, once you won the trial, you had to go have another trial essentially. Stage 2 was digging out all your receipts and proving what you were out of pocket. And you couldn't get anything besides that. You could get reasonable attorney's fees and actual expenses. So who wins in a situation like that? The lawyers. Well, I'd like to get rich someday, but not off the backs of people who are actually being forced to be microchipped as a condition of employment. So I said they need to have statutory damages where the legislature sets ahead of time what the dollar amount will be, and punitive damages, basically just allowing the employers in that situation to be punished for violating this law because it's so inhumane. They need to know they're going to get smacked down if they even attempt it. So the first lawsuit that goes through, the rest of them are all like, oh, did you see what happened? Like, let's not do it, right? That's the whole point of punitive damages. That and what was the other, oh yeah, and then the little part that they had in there, section 3, that said, well, you can't be forced to be microchipped unless a court says it's okay for you to be forced to be microchipped as a condition of employment. Because what judge on the face of the planet should be able to order a human being to be microchipped as a condition of anything? That's just disgusting. So anyway, so then what happened when I, let that whole situation be known is I had friends in the legislature like Michelle Huitenga who called me the woman. At least that's better than that woman from Michigan. I was the woman, I'll take that. The woman that does the videos. And my friend Jack O'Malley from up north who decided, he wanted to question my credentials. All of you watching, I won't say her name, but you should question her credentials. So of course the next day, the day before my birthday, I went around my office and I did a video showing all my degrees and things that I had earned. I figured being licensed in the United States Supreme Court to practice law gave me a little bit of leg to stand on, but whatever. So what's interesting is that in this bill, now an act, because they actually, it's now a law, doesn't mean it's constitutional, and it's not enforceable if it's not constitutional, but we'll get into that in a second. They put in here that a court shall award a plaintiff who prevails in an action brought under this act damages of not less than $5,000. What that means, let me back up and say that this plaintiff they're talking about is an employee aggrieved by a violation of this act. So an employee can sue an employer, right? So, yeah, I won't even go into all the ways that that's, whatever. So let's say someone reported health violations regarding COVID-19. Oh, well, my employer isn't requiring everyone to wear masks, and so they're reported, and the employer says, you're not welcome here anymore because we don't like to violate the fundamental or constitutionally protected God-given rights of our customers or our employees, so you need to find another job. Then, because they're let go, they file a lawsuit. This act now says that that employee can sue them and get no less than $5,000. So they're okay putting statutory damages in a bill like this that requires people to stay home when they go through a Michigan winter, but they're not okay with putting actual damages, statutory damages or punitive damages in a bill where an employer might try to force you to be microchipped. So, anyway, even the microphone is freaking out hearing that. Dang, I only got through my first point. Okay, I'm going to speed this up. So you all know the Secretary of State, of course, tried to come out and say that you can't open carry at the polls. Well, I've never been one to open carry. I've been a member of Michigan Open Carry for years and a recent member of the Michigan Coalition for Responsible Gun Owners. I don't like saying that one because that's a lot of words, and I'm blonde. I get that wrong. Government acronyms are bad enough, but then private organizations, whew. I open carried for the first time on Saturday while I was speaking at the Freedom Rally in Allendale. And I announced that, you know what, and it was ad lib. It was not something I was planning on doing or saying or, planning ahead as far as next Tuesday goes, but I decided the government's going to tell me, especially the Secretary of State, as an attorney who does constitutional law, is going to tell me that I can't open carry when I go to vote. I guess I'm open carrying. So, of course, now Georgetown Township's on notice that I'll be open carrying when I go to vote for myself. But luckily, the Court of Claims has ruled in the favor of common sense. So the judge issued a stay. Of course, the AG and the SOS are very upset with common sense and the rule of law having anything to do with government action, so they're going to take an appeal because, guns are scary and Republicans and Trump supporters are scarier, and so we can't let the two mix, especially on Election Day, because that's going to, allow the three Democrats that might actually have wanted to vote in person this year, they won't come. So, but I applaud the conclusion he came to, but here's the thing. He also said that, well, the Secretary of State can do that, but she has to go through the Michigan administrative rule-making procedures. Wait, what? So I'm pretty sure, anybody heard of the Second Amendment of the United States Constitution? Okay. Article 1, Section 6 of our state constitution? Yeah. So, all right, Ruth. Yeah, you're on top of it. So it's the same thing. We have the right to carry a weapon to defend ourselves, and Michigan's constitution specifically says to defend ourselves and our state. So other people, and it doesn't even mention in that the militia or anything like that. Like some people like to argue about the U.S. Constitution, Second Amendment, and how it, it's only about militia, and what does that even mean, and whatever. Our Article 1, Section 6 doesn't talk about that. We have a separate provision that talks about militia. So in any event, no matter what administrative rules and regulations that the Secretary of State wants to do, even if the legislature, because that's the other thing he said, is this is, it smacks of lawmaking, which it does. I mean, she can't do that. And so it should be wrong just on those grounds alone. But I don't care if it's the legislature, I don't care if it's the governor or the Secretary of State or the Attorney General, none of them are allowed to abrogate or diminish in any way, shape, or form our constitutionally protected, God-given liberties. In fact, every single one of them took an oath of office. Article 6 of our U.S. Constitution, Article 11, Section 1 of our state constitution. Even if you're just a school bus driver, if you are a teacher, if you are a secretary in a city council or in a city hall somewhere, MCL, meaning state law, 15.151 says that you have to take the same oath of office to have that job as the rest of the people that are required to take Article 11, Section 1 oath of office. So you have to uphold, I just realized you're giving me time, and oh my goodness, I got to get through these. I bet you're like just holding up notes for yourself.
Yeah, but you can take extra time, because we have Q&A built in there, and you're on a roll, so keep going.
Okay. So anyway, no matter what level of government you're in, what branch of government, you have an oath of office. Whether somebody told you or not, whether it was just one of those papers, with your your W-4s and all your I-9s and other stuff you filled out, you have an oath of office. So definitely our state legislature should know that, because, well, if they're making laws, they need to make laws that are constitutional. But anyway, so I don't care who you are, you don't get to make a law, a rule, an order, a directive that's unconstitutional, period. So I'm a little upset about the judge's ruling in that regard, that he seemed to suggest that, well, let's just push this out so it gives her time to go through these other procedures so that she can violate her constitutionally protected God-given rights in a few weeks. At any rate. So, we're also unfortunately in, but for now, as it stands, none of the poll workers should be challenging you open carrying. So, and for what it's worth, there has been no court case that describes this or clarifies this, but again, I don't get my rights from a court either. So, there's those provisions that you can't open carry in certain places, right? However, if you are going to the polls in a typical city hall that you might go to vote at is open for open carrying, well, the fact that your precinct is in a church or in a school or in some other place, it's not serving as a church or a school or whatever function it is. Otherwise, we wouldn't be able to have voting in churches, right? If a church was a church during voting, then what would all the atheists or Buddhists or whatever say, right? No. So it's serving as an extension of a government building in that regard, at least in that part of the building for that day, that specific limited period of time. So I'm telling you that you're totally good to open carry no matter where your polling precinct is. That's just me. Courts may not agree with me, but I am only 37, so I have a lot of years to fight them. And I will. Hey, at least now we know that we have another friend in the U.S. Supreme Court, right? So that's a good thing. So in this land of all this craziness, does anybody know what the final count was on the executive orders from Whitmer as of the time that they were declared unconstitutional? 192. Now, last I checked, about 11 were actually constitutional. Well, what's the difference between constitutional and unconstitutional executive order? Article 5, Section 2 of our state constitution allows a governor to make executive orders to reorganize the executive branch. She has to produce those to the legislature. They have 60 days to decide whether they want to essentially veto it or disapprove of it. And if they don't approve, and they vote to not approve of it, then it doesn't go through. It's dead in the water. So last I checked, I believe the number was 11 out of those 192 were appropriate. Put the number into context. From the year 1993 through 2019, when Whitmer was in office for a whole year, our whole state, as in the succession of governors we had during that time, we only had 605 executive orders written total. And then 1 year, she's written 192. Of that 605, 25 of those were emergency powers executive orders. And I want to say 7 of those were actually written by her in 2019, because we had the polar vortex and stuff. We thought we'd never forget, and then COVID hit. So she knew darn well what was going on all along. I was just the crazy attorney in the corner yelling that this is insane, and the 1945 law doesn't stand by itself, and you have to read them together, and it's unconstitutional and all that stuff. Well, eventually the court finally started to agree with me. even just for what it's worth, the governor knew all along, and I can tell you that if you look at her orders, in fact, if you look at any executive orders based on emergency powers from 1970 through 2019, including when she was in office issuing these, not a single governor used the 1945 law at all. They used the 1976 law. So the funny thing is, I was only able to research back to 1993, just the same as you can through the legislature's website. You can look on executive orders. It was actually the governor's own attorney in that Supreme Court case that filed supplemental briefing to let us know that they had done the research and that as far back as 1970, not a single governor had used the 1945 law. I was like, well, thank you for that piece of information. So, and in fact, I want to say the only times that 1945 law were ever even utilized in an executive order, I want to say it was maybe 6 times total, ever, before Gretchen. So, just putting that into context for you guys. So, obviously you guys know that the executive orders were struck down. There's 2 pieces to that, which I'm sure you guys know, but in case you don't. The one piece is that they declared that the governor's executive orders after April 30th violated the 1976 law. The other side to that is that they declared the 1945 law entirely unconstitutional. No governor in Michigan can ever use it again. Should it be taken off the books? You know, Stand Up Michigan's totally freaking out. You know, we still got to make sure it's taken off the books. It should be. Just the same, though, as you know, the whole laws around petitions in the first place. I don't know if any of you know, but in 2018, December of 2018, the legislature passed some bills that changed how we do petitions and what you have to have at the top. And so instead of it saying the county at the top, it would say congressional district, and then you couldn't have more than 15% of any of the total number of your signatures be from any one congressional district. Well, the Supreme Court, I want to say in 2019, struck that down as unconstitutional because then you're disenfranchising any of the other people that signed from that congressional district. And so they weren't very clear about what pieces they were all striking down, but anything that was basically relating to that. Well, if you go look up any of those laws on the books, they're there. It's like they still exist. And then you look down and it says compiler's note, and then it'll explain the court case. But it doesn't totally say which ones are total, you know, which pieces are totally gone or not. So have fun trying to figure out that one, because the night my petition went to the printer, my printer called me and he's like, no, you can't. And I was like, hold on, you know, we worked on this, we got it figured out. Now you want to tell me that I need to change it, and it's by congressional district. And so of course I had to do a bunch. I had an attorney helping me late into the night, researching all the cases and everything else, and just to get to the same conclusion I started with, which is no, we're good. We're going to do it by counties. But anyway, one of those examples where, and it's just one example, there's hundreds on the books where laws are totally unconstitutional. Courts have already even said they're unconstitutional, but the legislature hasn't taken them off the books. So if we're going to start cleaning up unconstitutional laws, we shouldn't just do it with the one just because it's popular and there's some media attention about it. We also, so what's important to note is that in that case, the questions before the court were specific because it wasn't the legislature's lawsuit against the governor. It was those 3 doctors' offices and a patient who sued as plaintiffs, suing the governor, the attorney general, and the Michigan Department of Health and Human Services. The reason why that context is important is because that was in a federal court case, and the federal court judge, again, I'm like the only person that's complaining about this aspect. The federal court judge said, wow, I went from 15 to 5. That was scary. So the federal court judge went and said, well, listen, if I can resolve this case, if the plaintiffs can win on a state court claim, anything to do with the state constitution or the state statutes, then I don't have to touch the federal court stuff at all. I don't have to say that she's violated the United States Constitution. And so let's do that. Now, what the state Supreme Court said, and they said it in oral argument as well as some of their writings, they said, I want to say it was Justice Viviano really kind of hammered on that he appreciated that it seemed like it was deference to the state courts about that. I don't care who gives respect to who at this point. If she is violating the United States Constitution, shouldn't they have an obligation to declare that she is violating the United States Constitution? Don't take the easy way out. In fact, if she's violating the state constitution, get the state's highest court to say that, and then turn around and say, okay, but she's also violating the United States Constitution, and she's violating this statute and that statute, and people can sue her under 42 U.S.C. Section 1983, and she's criminally liable under 18 U.S.C. Section 241. I mean, lay it all out there. Why take the easy way out just so you can stay as politically neutral as possible? Because your next stage might involve needing the nomination of somebody that you got to be connected with. You don't want to tick anybody off. So I was accused of trying to really run for office and seek some big political high office at some point, and I thought, man, you guys, anybody who accuses me of that is really stupid, because obviously I'm not trying real hard to kiss butt. So at any rate, we need to pay attention to those things. And so it's not that the court said the 1976 law is constitutional. In fact, what they specifically said is, because they answered the question that she violated the 1976 law, they didn't acknowledge whether she violated any law or any constitutional provision before April 30th. It wasn't that they said it was okay before then, they just didn't answer it. They also didn't answer the question about whether the 1976 law is unconstitutional. They said, we don't have to address that question. Yeah, you probably need to do that because, the next time there's an emergency, I mean, COVID's here to stay. So, are we in the next season of it? I mean, if she had been smart about it, she could have stopped the lockdowns and everything for a few minutes, and then she could have restarted back up when the new flu season started up, because it's a form of flu, so it's going to follow the cyclical patterns of flu, and whatever. October is when they start officially, but she kind of screwed herself on that one, because now it's just one continuing season. So at any rate, what's important too is that the court did not answer the question about whether the 1945 law is unconstitutional because it violates our liberties, or because it violates any other provision. The only thing the federal court asked the state court to do as far as determining whether it violated the state constitution was, does it violate Article 3, Section 2, the separation of powers clause and the non-delegation clause? What's really disgusting, though, I'm going to be honest, and this is coming from Justice Markman, who, for the most part, I, admire in some of his writings and things. He really let me down on this, because he's the one that authored the majority opinion and said that he kept calling it, oh my gosh, I'm losing the word, like a notion, declaration, no, that's not it. Doctrine, thank you. A doctrine. Well, in the United States Constitution, you could call the separation of powers clause a doctrine, because we have Article 1 that talks about legislative powers. Article 2 talks about the powers of the president. Article 3 that talks about the powers of the judiciary. And we don't have anything that spells out the phrase separation of powers or non-delegation or things like that. In our state constitution, we have the similar setup. Article 4, Section 1, Article 5, Section 1, Article 6, Section 1 gives those powers. But go backwards, Article 3, Section 2 spells out, it literally says we have separation of powers. It's not a doctrine. It's actually written in there. It's a clause. And the non-delegation piece, that's the second sentence. It's not a doctrine. It's not a theory. It's not a notion. It literally says in there, if you are in the executive branch, you cannot exercise the powers of the judicial branch or the legislative branch, or vice versa. You cannot exercise the powers properly belonging to another branch unless it explicitly says that you can somewhere in the state constitution. The only place that it says that is Article 5, Section 1. I am being booted. Do we? Okay.
To give us. Let's see, we got this. Okay. Yeah, there were two other things. One was, it appears the governor is trying to do an end around on the Supreme Court through the health department by weaponizing different government departments. I'd like you to speak a little bit to the legality of that, and a little bit on the Christian school that's being harassed right now. Take another 5 minutes,
Okay.
because those were two other points I really wanted people to
Actually,
hear
just
about.
getting into that. That's why I explained the court's decision the way I did. So what the Department of Health and Human Services director has said, he actually made quite a mockery of things, and am I doing that? Okay. Oh, okay. So he made a mockery, and so of course you guys probably remember that on Friday, October 2nd, when the court came out and declared, issued their opinion, the governor's out there within 5 minutes saying, my orders still have 21 days. You have to follow them for 21 days. That was a load of garbage, and she's a licensed attorney, and she knew that. If anybody wanted to file with the Attorney Grievance Commission a complaint, go ahead. In fact, I had somebody that I directed to today on how to do that. It's definitely, there's huge problems with her doing that. That was never a thing. That's not even a stretch of a thing. She quietly on Monday, the following Monday, filed the request with the Michigan Supreme Court to give her 28 days because she wanted enough time, as she wrote in her motion, to put in place her other executive branch tools to control us and to control the spread of COVID-19. And then, as a side note, maybe work with the legislature. So the legislature filed their brief opposing that. I filed my brief. The plaintiffs filed their brief opposing it. Of course, the Attorney General filed the briefs in support of it. No law cited whatsoever by the other side, let me tell you that. If you haven't read anything, though, read the briefs or responses to the motions that myself, the plaintiff, and particularly the legislature filed in response to that, because a lot of it gets really legalistic at times, especially the briefs. Those response to those motions, that motion, it was beautiful. You guys really do need to read it. And I have those on my website, restorefreedomkh.com, under the resources tab. But anyway, the thing is, he was saying that basically they were both trying to make it sound like, well, the 1976 is totally constitutional, which wasn't a thing. And that, it was, the governor did everything she was supposed to do. She followed the law. It was the mean old nasty legislature in 1945 that enacted it. I'm pretty sure there was a governor there signing it into law back then. But anyway, they're using that philosophy when on Monday, the director also issued the first of these. Now, keep in mind, April, I think, was the very first of these emergency orders that MDHHS put into place. It was very quiet. I actually had a back and forth with a state rep, I forget regarding, however, it came up in a bill. But there was a bill that he introduced that could have done some good and could have stopped all this and clarified things, but no, because their legal counsel was telling them that whatever. I won't even go there. They've been making it in addition to the criminal penalties. They've been making with those orders an additional civil penalty with a fine of up to $1,000, plus the licensing violations. They've been there all along. So really what happened on Monday, October 5th wasn't really new. But throughout the week, he issued a bunch more orders requiring a bunch more things. The thing that really is frustrating about that is doing summary proceedings, it says, to strip you of your business license if you're found in violation of, one of these orders. The thing is, summary proceedings means you don't get a hearing. They just strip you of your business license. Good luck. You get to go through this particular administrative court proceeding to try to get it back, and it's really not ever going to happen. You don't really ever get a day in court. That's what that means. That's always been a thing. That's why I was, trying to tell some state reps with some good bills that could have done something way back when. So anyway, what they're trying to do is, they're trying to utilize the Public Health Code, which is the reason why I wrote the Restore Freedom Initiative petition, because the Restore Freedom Initiative petition stops all those pieces. It doesn't just attack the 1945 or the 1976, but it attacks the Public Health Code, the bad pieces, and all these other things that are happening. In fact, it would even stop, if this were happening 2 years from now, it would actually negate the need for the 1.2 million signatures for the recall, because in my petition, if that were a part of the Constitution come 2 years from now, and this were happening, then when a governor or any government official intentionally violates the state constitution, that's a misdemeanor on the first offense. No more hiding behind this immunity garbage. It's a misdemeanor on the first offense. The second offense, it's a felony, and you're immediately removed from office. No need for 1.2 million signatures. And you're prohibited from ever holding public office as a state or local official ever again. So unfortunately, it's not in place now, hence the need for, a recall or whatever that people want to do on that. But at any rate, so sorry, I lost my train of thought of why I brought that up, because my point wasn't to divert into talking about the Restore Freedom Initiative petition. But so the Public Health Code, again, I'll just say real quick 3 things about what that law does. Now, whether it's a local health department, apparently Ottawa County is deciding to crack down unconstitutionally, or whether it's the statewide directive, same thing. The law says the exact same thing. One is MCL 333.2253, one is MCL 333.2453. It allows 3 things, though, for the same thing. One is that I won't comment on it at this exact moment, but the law claims to allow the director or whoever, the local health officer, to issue an order to prohibit the gathering of people for any purpose. Yeah, we'll come back to that in a second. So that's allowed by statute. And then the second thing is they are allowed to, the third thing is they're allowed to enforce any public health law. Well, there's no law that you have to wear a mask. I mean, who knows what the legislature has been trying to work on the last few days. Last I checked, there was no law that allowed a mask to be a requirement, things like that, contact tracing in a business, that kind of thing. Those were all things that were attempted in Senate Bill 858, but, and so that you can't enforce something, new, right? So the second thing, the one that I skipped over, they are allowed to issue these orders to ensure the continuation of essential public health services. Now, I've done a whole hour video about this, so all I will say is, to boil it down, if you want more information, I do have a video about it. I do have a lot on there about on my website and YouTube channel about it. But public health service, first of all, is boiled down service. If you look in Black's Law Dictionary or anywhere, a service, that's like the guy who owns the teenager that started a lawn mowing business. If he's offering a service, he goes to your house and he's like, hey, I want to mow your lawn. If you say, no thanks, I don't have any extra cash right now, or gosh, I have my own teenagers, thank you, then it's a service. You can deny that. A service is something where you offer it, it's of benefit to the other party, and they can deny that. They don't have to utilize it. Requiring people to wear masks, how is that a service? How are you offering a service to them? Arguably, if they wanted to say in government buildings, government buildings would have to offer masks, have them on the counter. They could offer education on COVID-19. Those who are immunocompromised, ways to build up your immune system. Not that they want people to build their immune systems. They want to keep people sick. But, they could offer that information, right? That would be a service. So at any rate, there's no contact tracing, not a service. That's a service for the government, not a service for us. What is it? Temperature checks. If I wanted my temperature checked, I would, take out my thermometer at home or go to my doctor. I don't need, Macy's or whatever to check my temperature. All the wearing of masks, none of it is a service being offered. And certainly they're not essential public health services. What are the essential public health services they're supposed to continue? The whole point is that when you have a pandemic or you have something awful, that you're continuing to still offer, say, mental health services or drug abuse and addiction counseling or, stuff for domestic violence, abusers or victims, or parenting classes for those with abuse and neglect cases, regarding their children. Those would be essential services. Pregnancy testing or ultrasounds, right? Those are essential services. If the government's going to do anything with healthcare at all, that would be meant by an essential public health service. But they didn't focus on that, did they? No, they stopped AA, they stopped NA, at least, during part of this. They stopped doing all those non-essential health services. Well, they are essential, but anyway, you get my point. So go back to the first thing that these laws say they're allowed to do, prohibit the gathering of people for any reason, so they can prohibit us from worshiping on Sundays or any other day, quite frankly. They can prohibit us from gathering peacefully, or, peacefully assembling. pretty sure that language is somewhere. Petitioning the government for redress of grievances, usually you do that while you're gathering. Consulting for the common good, instructing your representatives. Those are all rights given to us by Article 1, Section 3 and Article 1, Section 4 of our state constitution, and of course the First Amendment to the United States Constitution. So that is the thing that's like so blatantly obvious that they can't do, and yet they're trying to do it. So limiting the amount of people that people can have in their businesses or things like that, a no-go. Did I answer the question maybe enough, or?
We need to hand you back because we didn't give you enough time tonight. Keep rolling because this is a group that's not worried about getting on the door in the next 5 minutes. We love what you're sharing with us, and we'll have to limit it tonight, but we will have to have you back because
I'd be glad to come back.
our freedoms are tremendously threatened, and you're just a canary in the mine telling us how bad it is.
Yes.
We need to hear more.
Yeah, so definitely, you know, what is it, the way that you make God laugh is to tell him your plans, right? So some of you who have watched my videos or know of, I've been dreaming of moving to the beach in Florida. I have a college sophomore. I know I only look like I'm 20 myself, but I did mention my husband's older. So college sophomore, we have 2 high school seniors, and I have a 6-year-old. Normally she's dragged with me to every event. Luckily, her college sophomore sister decided to pick her up, and she's an education major, so she's going through homeschool assignments tomorrow. So that means I don't have to check those. That's great. I get a day off to work, I think. Anyway, so I initially planned on leaving Michigan in May. I was going to list the house, you know, have everything out. I have a feeling God's calling me to stay, but maybe we can get this fixed. So I really would like to take December off, though, if I could. But so just as an aside, if anybody does have any, you know, if people do have to get up and leave before we officially close out or whatever, I certainly will come back if you guys want me to come back. I'm going to continue not making friends, so I'll be, you know, not the person to hang out with if you don't want to get in trouble with the government. But if you have any questions for me as an individual, the one thing I will ask is I literally get thousands a day now, thousands. And I'm not doing any of this for pay. If anybody wants to donate, restorefreedom.com, restorefreedomkh.com is my website, and you can donate on there. Literally, all of this has been by donation. We have donations specifically for the printing of petitions. We have donations for the legal work. I have to buy a new printer because we've bought like tons of toners and cartridges and drums and things, and it says no, I quit. But the biggest thing isn't so much that I'm not getting paid officially for this work, it's that I'm only one person. And I love my super smart, sexy husband back there, but he's not an attorney, he's a machinist. And he works at the machine shop during the day. And I don't have staff. I have some volunteers that come and go to validate petitions and do other things. I don't have legal staff. So I want to make sure I answer all your questions. If I don't get them answered today and you know you don't feel like you can wait until the next time you might have me back, I do live videos. What are you showing me? Oh, I do have cards back there, but I appreciate that, and you're more than welcome to take the cards. They'll have you can scan the QR code to get to the website, you can do whatever, but I'm so far behind. I have people that have been waiting since July to hear from me, or even June, and I'm trying super hard to get caught up, and I'm drowning. So if you have questions for me, every single question I can guarantee you is important, but I can guarantee you it's just as important as the next emergency. Even the people on my own team, they'll have an emergency and they'll be like, okay, so Catherine, I need you to look up this statute. I need you to tell me. And I'm like, dude, even you know I don't sleep. You know, I work every single day, 7 days a week. So I just ask that you don't try to reach out to me individually to send me an email or whatever, not because it's not important, because I'm really behind. And if you can ask me a question during a YouTube live video, if you do that, or Facebook Live, or wait till I come back, that's all I just wanted to say.